Matter number one,
Please, madam. Yes. And this matter is pertaining to dismissal of a complaint, even without examining the complainant and the witness, which is mandatorily prescribed under section 223 of DNSS and earlier 200 of CRPC.
What happened? What were mandatory? What?
Examination of the complainant and the witness before taking cognizance of the offense.
So notice will go.
Normally, my lord, this coordinate bench of this honorable court has in many cases they have remanded the matter with a direction to proceed the case as per the law, as per the statutory provision provided in the law.
Where is the order?
Order is, my lord, page 33, my lord. Complaint was dismissed on first date on motion stage itself. Down assigned is that is of a purely civil in nature.
Let this case, let the notice go, then we'll consider.
My lord, in this case also, my lord, here in the lower court, even notice was not issued. So, in a similar situation of case, honorable court of our high court has held that on motion stage itself can be dismissed, disposed with a direction.
You have that?
Yes, I have the judgment.
Yes. What happened? Yes. Okay, let me see what he submitted. This is the same case which has been referred here.
Yes, in 2022 judgment is referred in 2009. Judgment on last paragraph observed. That's it.
Let us see the order of the CJM, page 33. Saying that it's a civil nature.
Yes.
That's what you have to say. Which paragraph? Fifty. 1 second. Yes.
Lordship, this judgment is clearly distinguishable because this judgment passed in the case where a complaint was dismissed under 203, now 226. In a 203 or 226, complaint can be dismissed after examining the complainant and other witness on oath.
No, here it is 203 in your case.
In your case, now presently on DNS is 226. But in my case, my complaint was not dismissed under this provision, my lord.
Your complaint was dismissed under what?
Just dismissed, my lord. Not mentioned any provision. Merely observed that it is of civil nature.
It will be dismissed under which provision?
302.
It has to be dismissed under some.
After 226, my lord, for dismissal under 226, complainant has to be examined and other witnesses has to be examined. If Honorable learned magistrate found that there is no sufficient ground to proceed, then they can dismiss the complaint. In that case, opportunity has to be given to the prospective.
How the case is distinguishable from this case to this case? That you just
because in my case, my lord, no examination was made of the complainant. I mean, here 223 was not compliant. May I take my lord to the 223 of the DNSs?
What is the fact in this case? Whether he was examined or not examined?
In the judgment which my brother is referred is of the case where other complainant and other witnesses were examined.
After examination?
After examination.
It was not in limine.
Not in limine. After examination, the magistrate found that there is no sufficient ground to proceed against the prospective accused. So they
then they have dismissed.
Then they are dismissed.
You see the factual part. No, that is a relevant point.
Again, the other what provision the complaint is dismissed? First of all, this is 226 corresponding to section 213 here. Under the provision only it can be.
Correct.
Once dismissed process, it cannot be redo its order. It has to go forward and only remedy is report is high court for quashing. But now here in this case, your Lordship, under 200, the government clearly said, okay, under 200, any order is filed. Your Lordship, cognizance part, my lord. It's a very cognizance is not defined in here, or even in the PNS. It's occur when instead applies judicial mind to substantive commission of offense. Here, my lord, order, whether it's a purpose order or not, is subject to consideration by this court. But the question still remains here is, my lord, in revision petition, my lord. If you, my lord, go 401 of the CRPC or my lord, PNSS, my corresponding section, the provision clearly provides, my lord, the implement is mandatory because the person must be given an opportunity. Here, the judgment also says the prospective actor must be given opportunity to file a revision because it's mandated under 401. It's even said because of the factual effect, it's to take into consideration.
Let us see 401. What is it?
Take my-
401 IPC. Sorry, DNS. Say CRPC.
Lord,
401, which provision?
Subsection 2, my lord.
my lord, before that I'd like to clarify. My revision is not under 401, which is corresponding to 330. Uh, 442. Mine is under
You are filing under 528.
read with 528.
Filing under 528.
Yes, basically it's 438, my lord.
430.
Yes. Now,
My lord, again,
earlier it was a 397 in the CRPC.
power is there in 401.
No, there's they are distinguishable in these two provisions.
No, this is
Not different.
528. 528 is inherent power.
Inherent.
Power. Why? Revision wise. Because this is the final order. This order leads to the culmination of the.
My lord, 438 read with 528. Kindly go through my post title. It's clear. And 438 is the earlier 397 of CRPC.
Earlier, 397.
397.
What is 397?
397 is
Excess
power and revision. Also in 397, earlier also it was not given provision for a compulsory making party. But in 401 earlier, it's mandatory to give opportunity to the accused. But it's not in the case of 397 or in the 438 of BNS.
No, whether see like the object behind making a person a party is like if any order is passed, then whether that will cause any prejudice to the to that party. But in this revision, since out there also there was no there was no process
No process.
issue. There also that person was before the person appeared, it was dismissed. Correct. Now here also is coming in the same kind of situation, right? So if there is a case he makes out, and if he it is remanded to that judicial magistrate, then what prejudice will be caused to him?
But notice it could be, but we will more.
No, no, that is not the question. Question is that like I mean he has filed a complaint. See, so mandate of this thing is very clear, no? Very clear that without once the complaint is filed, without conducting any inquiry or without hearing or recording the statements, simply he has dismissed it. Correct. So in that situation, he doesn't have any other forum but to come to the High Court. And what in the High Court, what he is seeking? He is only seeking that that what mandate was on there under Section 200 that was not complied with. So he is only seeking that. So if this court is convinced that yes, that mandate was not followed, then in that circumstances, if this court passes an order, what prejudice will be caused?
One more before the opinions now the PN is right of the
Hmm.
opinions.
Hmm.
Now from the many earlier questions,
Hmm.
if you put any opinion,
Hmm.
in the geologic is always very clear. The geologic, the prospective action, in revision, this opportunity to the person has to be given. Initially, the procedure.
No. You
No,
you just distinguish it from the from this case that we have given it to me. See, you see the factual thing there. I mean, you have just given me one paragraph. You see the factual stuff and like and give me the factual details. Then only we can see because the facts may be different there.
Right, also, my lord, he will come on scene only if I make out case before the landed court below. Otherwise, the court below will dismiss after taking a statement or examining the complainant and the witness. If I fail to make out, if I able to make out, then only notice will go to the party, my lord.
Which but the inquiry was conducted or not? No,
Inquiry
because
was
the magistrate ordered for the inquiry.
Yes,
Then a report was submitted.
yes.
Then after finding that it's a purely a civil nature, then we come to paragraph 48. Go on, go on. On a. Hmm.
You say that person do the application of the protect state from the
What do you have to say on this?
My lord, here inquiry is made. Making inquiry
No,
through.
no, it specifically states that whether it's a pre-process stays or post-process stays, it doesn't make any difference. The person has to be given opportunity to be heard. Because it is kind of a reversal of the magistrate's order.
Yes, it's there.
So this 48 covers it, what he is submitting. It is very specific.
But my lord, here a pre-process or post-process, my lord, things that at least examination of the complainant or witness or inquiry through magistrate, that has to be complied, my lord. And then only, my lord, if a complaint is dismissed, pre-process or post-process, here also inquiry was made through police. Without issuing process, complaint was
But
dismissed.
but it says pre-process also.
Yes, my lord.
Pre-process means nothing was done without any inquiry.
Pre-process basically inquiry, but before issuing notice to the accused, because
Yes. You tell me what is pre-process mean.
pre-process, to my understanding, my lord, is that here, as per 200 or now 223, first complainant and a witness has to be
So
examined.
once a complaint is filed,
Then complainant or a witness present in there has to be recorded. And if prima facie make out a case,
then
process will issue. If no prima facie, then no process. Then it can be straightway dismissed under 203. Or otherwise, in here a magistrate can make herself or himself make inquiry or ask police to make inquiry. If after inquiry they found that there is no sufficient cause for proceeding, then the case can be dismissed pre-process. But if a report says something, disclose something, some commission of offense, then a process has to be issued. Here, pre-process is also, my lord, to my understanding, is too different. Pre-process, in my case, not even the complainant was examined, nor any inquiry was made. That's one stage. And another stage of the pre-process is when a statement of the complainant and witnesses were taken or inquiry is made.
But
So
what basically you are submitting is that here no statement was also taken.
Yes, my lord.
And though it was in the pre-process stage,
Yes, my lord.
no inquiry,
No inquiry, no statement.
Statement of the record was recorded. Only on the basis of the complaint it was dismissed.
Yes, my lord. In the present earlier case, because once inquiry is made, something come out in favor of the prospective accused. And in that case, you will have certain right because the observation is already made by the honorable court or through the police or from the statement of the complainant or the witness, some right is accrued to the prospective accused. But in my case, since no any statement was recorded, no any inquiry was made, no such any right of pre-hearing is accrued in favor of the prospective accused.
Yes, Mr. AK. See, yes, you explain the what is pre-process stage.
After process, I didn't understand.
No. You tell me what is the procedure there before the magistrate.
Actually, a complaint. Complaining. Then he was inquiries.
Hmm.
Both see whether if there is a complaint and whether there is a
So he'll basically see the contents. Then he will see that if there is any inquiry is required, he may direct the police to.
purpose of it.
Hmm.
And then, if again you also the concern states, other things are taken. Their statement will be also taken. Then my lord, what court will do? Normal procedure, the court will take complaints. After coming from the PNS, it is given up. Okay, their case is taken to.
The notice will be issued to him and
Yes.
like. Hmm.
And then you know, they get for the clearance. If the magistrate find that there is further requirement of confirming whether there is a ground, sufficient ground to proceed with the case or not, then there is a rescue of either magistrate will inquire into the matter by himself or direct the police to investigate the matter. That is not in consonance with the one's So then the police file report. Either police will file a report or magistrate will inquire.
Hmm.
And then you know, if the magistrate find that there is no sufficient ground to proceed with the matter, then under 203, magistrate will issue the complaint.
Complaint. But in this case, nobody was examined, no statement was taken.
But you know, if the judge makes a complaint which has been issued against an accused, that has been dismissed. Once it is dismissed, you know, it will become a matter of moment for the accused. But against him, there is no any proceeding pending for the court. Because of the dismissal, they have challenged an impugn order. So now, if this order is revived, it will become a prospective accused. So for that, you know, taking into consideration, the complaint is right, there are 48. It says, you know, the pre-process, section under 200, only your lordship, only your lordship, the statement of the complaint record of the witness. Even if that part is not done, but this is rightly or wrongly, it is subject matter to be decided by this court. But what your statement that is prospective accused must be given an opportunity. Although he do not have any right before the ordinary proceeding unless
Process is issued.
yes, but he must be given an opportunity. And so far as section 397 says, you know, section 397 also says for the record to analyze the court whether the purpose order was or whether the correct order or not, the correct order, wrong order was passed by court or not. That has to be looked into. Whether he was examined or not, that has to be looked into. What other material was there? Although from the case of the order, it seems to be perverse. I'm admitting that one. But what is there? What materials, other materials, whether he has examined the accused or not, complainant or not, that has to be looked into. Because that is why the 397 is there now. That board has to consider whether the propriety of the legality of the part by any kind of illustrate. And so
Have you submitted any other documents? Nothing.
Here, my lord.
No, I mean, what have you submitted? What's
No, my lord, actually, I just want to save a precious time of honorable court because it will be a kind of futile exercise to issue notice to the prospective accused and come back when.
that I'll have to be
Yes,
convinced
when-
whether issue notice is
Yes,
required or not.
yes, my
Because there are some settled laws.
Yes, my lord.
You have also submitted two
Yes, my
cases.
lord. Since on the base of the record,
And
it
Supreme
appeared.
Court also says something on this.
Yes,
So that has to be seen.
yes, my lord.
in proper perspective, isn't it?
Yes, my lord. Otherwise, my lord can issue notice.
Yes, they've implemented, I've seen that. Impleading, you have already impleaded and you don't want me to issue notice. You want this to be disposed of at a motion stage. So your complaint is at page 25, right?
Yes, my lord. Yep. Yes. Yes, my lord.
No, he has to be heard.
Yes.
What is this? This is heard, Mr. Your name?
Laji. D. Laji.
Nilazi, learned counsel, appearing for the petitioner. Also heard. Mr. T. appearing for the state of Arunachal Pradesh, respondent number 1. This is an application under section 438/528 of our BNSS 2023 for setting aside and quashing the judgment and order dated 8/7/2025.
वो तो step तब हो जाएगा, time लगेगा.
Is it a judgment and order?
Final order, my lord, who dismiss the case.
No, order passed by the learned Chief Judicial Magistrate Kepodijo, Upper Subansiri District, Arunachal Pradesh in CR case number 5/2025 in bracket Srimati Yake Sorum versus Sri Tabom Guha, bracket complete, under sections 223 and 227 of BNSS 2023. I will not record the submissions, sir.
Of my lord.
Because it's not required.
Yes, yes, my lord.
Issue notice to the parties. Notice upon respondent number 1 is dispensed with as Mr. Ete. And Ete enters his appearance in the case. Notice on respondent number 2. Returnable within 4 weeks.
My lord, 2 weeks. No, it's possible. 2 weeks.
Okay, notice to respondent number 2, returnable within 2 weeks. The counsel for the petitioner will take steps for notice, for serving or service of notice on respondent number 2 by registered AD as registered AD as well as under due under the normal course. Let this matter be listed after 2 weeks. Yes, registry may call for the PCR of the case from the court of
No, no. Chief
Civil-
Judicial Magistrate.
Chief Judicial Magistrate Deputy.
Deputy.
Let this matter be listed after 2 weeks.
Yeah.
You just put that CR.
Most obliged, madam.
CR number 5 of 2000.
Item number 2,
May I please, madam?
Yes,
My lord, in this case, the petitioner has been convicted by the learned CTM here for to undergo RI for 6 months. For
Hmm.
commission of offence under 420 of the Act.
Hmm.
Thereafter, my lord, the petitioner has filed an appeal before the learned section judge.
Yes.
Wherein the learned section judge has dismissed the appeal
Hmm.
summarily on the first day itself at the motion stage.
Hmm.
And in fact, my lord, if on merit, if I may go, my lord, the learned trial court as well as the appellate court has failed to appreciate that in order to constitute an offence under 420 of the IPC, there has to be an intention. There has to be, in fact, dishonest intention from the very inception. Now, since I have filed an IA in this case now, I'm only praying for the consideration of IA at this stage, since I have been convicted only for a fixed period of 6 months. And after conviction, my lord, I have filed an application before the learned CGM, wherein I have been, my suspension has been considered. My lord, may kindly have page number 45 for a time of the menu.
Yes. Yes. Yes.
Also continue on paper. Therefore, my lord, since it's a certain law, in fact, there are certain observations of the Honorable Supreme Court as well. Since the conviction is only for a fixed period of 6 months, my lord, until disposal of the revision, my lord, that may be kept into arrangement. Thereafter, my lord, the revision can be. Otherwise, from the record on merit, I can show that the London Trial Court as well as the appellate court has failed to appreciate the.
You are submitting that list, for 6 months, it should be
My lord, at
kept
least-
in abeyance.
Yes, my lord.
Then your 6 months conviction, I mean, that period will be over only.
That will be after the outcome.
I know, I know.
Sentence, my lord.
I know.
But since he is on bail at the moment.
But what is this? I mean, it's come to 45. Accordingly, prayer is allowed. The sentence is suspended for 30 days from the date of this order.
In order to file an appeal.
No, wait, and date for this order, and convict Vidamaya is allowed to continue on bail granted by this court by order dated 15/5/2015.
It's the case of 2015. Otherwise, it should have been my lord, suspension of the execution of sentence after conviction. But in this case, 13.
So you have filed an IA also here.
My lord,
Where is the IA?
I
Yes. But what about the interim prayer? Already on the bail. You were sitting there,
Yes.
heard Mr. J Sering, right?
Right.
J for
Jumping. Jumping.
then J. Heard Mr. J Sering and learned counsel appearing for the petition. Also heard. Learned FT Gini, MST Gini, learned APP for the respondent number 1, comma state of Arunachal Pradesh. Instant application has been filed by the petitioner praying for suspension. The instant IA, right? Instant IA. In suspension of sentences, the sentences and granting of bail, comma, during the pendency of criminal revision petition against the impugned judgment and order dated 26/8/2025, passed by the learned session judge, comma, UPR, comma, in criminal appeal number 10/2025, as well as the impugned sentence order dated 8/8/2025, comma, pronounced by the learned chief judicial magistrate, comma, Papumpare, UPR, in GR case number 06/15, comma, convicting the accused Vida Maya under section 420 IPC and sentencing him to undergo rigorous imprisonment for 6 months and payment of fine of rupees 1 lakh only in default of payment in default of payment of fine, the accused shall further undergo 2 months simple imprisonment. Which was the page 45.
My lord.
Mr. The learned counsel for the petitioner submits that
Yeah, is page 38.
page 2 submits that the petitioner is presently on bail on the strength of the order passed by the Chief Judicial Magistrate at UPR District Papumpare, Arunachal Pradesh, dated 8/8/2025. Therefore, the counsel for the petitioner submits that he may be allowed to stay on bail till the disposal of the connected revision petition, connected criminal revision petition. I have heard the parties consider the materials on the call. On consideration of the materials on the call, this court is of the view that the petitioner may be allowed to remain on bail. Full stop. The prayer is not there.
My lord, the bail can only be granted after suspending the execution of sentence.
The prayer is there, but suspension then
Granting bail.
the power under 389, which is for suspension of sentence and granting of bail, is akin to section 401. There's a ample of power for this honorable court to consider that. 401. Might not kindly have section 401 of the CFS. Four 42 of the ENS.
401, yes.
Okay. Others have the CFS.
Yes, I have it.
High Court's power of revision. In case of any proceeding, the record of which has been brought for by itself or which otherwise comes to its knowledge, the High Court may in its discretion access any of the powers conferred on the Court of Appeal by section 386, 389, 390, 391, or on the Court of Settlement by section 307. Now, 389 deals with the suspension of execution of sentence and granting of bail. Therefore, my lord has the power. Therefore,
Let's go to 389.
389. Yeah.
Yes.
Suspension of sentence pending the release of applicant on bail. Pending any appeal by a convicted person, the appellate court may, for reasons to report by writing, order the execution of sentence or order appeal against suspended and also in case he confines the release from bail or on his own.
Yeah, it is there. Power is there. Yes, correct. But see, pending any appeal by a convicted person.
But
Appellate court may.
under 401, High Court can invoke this provision.
Hey, we read 401. 401 says, in case of any proceeding, the record of which has been called for by itself or which otherwise comes to its knowledge, the High Court may, in its discretion, exercise any of the powers conferred on the Court of Appeal, conferred on Court of Appeal by sections 386, 389. So 389 is appellate power in appeal. So under 401, the High Court has the power of an appellate court also. Of this, so 389 power it can exercise. Mhm. 389. Okay. Let us review it again. Yes, let us be clear about this. Pending any appeal by a convicted person, fine. Appellate court may, for reasons to be recorded in writing, order that execution of sentence or order appealed against be suspended. There is no doubt about this. And also, if he is in confinement, that he be released on bail or on his own bond, provided that the appellate court shall, before releasing on bail or his own bond, a convicted person who is convicted of an offence punishable with death or imprisonment for life, provided that he is convicted of release on bail, it shall be open all the way to further. modification. Then you are basically stressing on this, if he is in confinement, if he is in confinement,
No, sorry. He's on bail.
Hmm?
He's on bail.
he is under. No, but that has to be then again extended there.
Since if the order is suspended, my lord,
Hmm.
the,
Automatically it will go. So that you can approach there.
if required, my lord.
It will-
Otherwise, since if the order.
Yeah, but like your order is for only 30 days probably. So it has to be extended.
But if my lord suspends the order of the landed chief judicial magistrate as well as the session bench,
Hmm.
then I may not be required to file an application. Since that execution of that sentence has been suspended by them, therefore conspicuous to follow. I don't have to apply for it. My lord may observe that the order of the landed CGM as well as the session judge may be kept, may be suspended, and then I may be allowed to be on bail as per the order of CGM. That will continue on bail.
What will do? Whatever. Petitioner may be allowed to cut off. That this court is the opinion that delete that part. Next paragraph. Which was the order? The order
Order
page,
2025.
page
Page, my lord, 16, my lord.
60.
61, 6, my lord,
1/6.
of the IM.
Yes, yes. In view of the above observation, the order dated 26/8/2025 is hereby suspended. Since the petitioner is already on bail, no specific order needs to be passed as regard to that. I will not pass any order on that,
My order dated 26/8/2025 as well as order dated 8/8/2025.
8/8 is passed by the learned CJ. That I'll put in.
Manitil, my lord, may kindly issue notice to the response.
Issue notice. Issue notice on the respondents. Notice on respondent number 1 is transcripts as the T. Ginny Lanet APP entered appearance. Notice on respondent number 2 will be served by way of registered post with AD as well as in the normal course, as well as in the usual course. Petitioner, the counsel for the petitioner will take steps for notice within 2 days of passing of this order. Let this matter be listed after 4 weeks. This is in IA in the this thing also. So I'll admit this. Admit issue notice returnable within 4 weeks. The counsel for the this one I'll dispose of.
My lord, the IM can.
IA can be disposed of. So that notice is not required in the IA. IA is disposed of. In the main case, you write that notice partner, you write in the main case. A call for registry may call for the PCR. You write that this court and the case number.
Item number 3.
Yes, Mr. Patin.
Yes. This is pertain to the Itanagar PS case number 72 of 2025.
Where is the FIR?
FIR is page page 16.
16.
See,
Type
Yes.
copy is at 19.
yeah. Page 16. Yes. And
The undersigned is the investigating officer, so that while undertaking
this
investigation.
is the page
19.
19. This is the FIR.
The investigation,
Before going into this.
oh, then it has to go to that.
Yeah. Then I do not.
But notification says about similar cases or where is the notification? You have that notification? It is from the same FIR.
Earlier two applicant lordship, Tapang Ulu and Paratutin
Sorry?
moved file reports, before.
And you write, as has been pointed out by the learned PP, a similar bail application arising out of the same case number 06.
Oh, no, here in a case, we're only in 72. I'm not connecting with the 06. Two FIR. And in 06, I have been
In the same
granted
case,
bail.
2 FIRs have been filed.
I have been granted bail in 06.
Lordship, the application number is not there, lordship. Paramount file application on the disclosure made with this application. Was arrested and bail was released.
So let it be listed before Mr. Habong.
No, let the notice be issued and he's coming, and in the meantime, it will be taken up by he in his court. Only today is only the case that he may be called for. Because
No. If there is a notification, then this court may not be able to take it.
No, hearing will be done in his court, but notice may be
No, notice also it may not be able, I may not be able to issue.
and issues are very much different, my lord. The question which I raised, it is only confined in law.
Let it go to, because this is very clear, Mr. Patel. I'm sorry, because this is very clear about this notification. As submitted by Lanet PP, that a similar case, a similar bail application is still pending. No? A similar bail application has already been disposed of by a coordinate bench of this court arising out of the same FIR. In view of the notification issued by the Guwahati High Court dated 30 May 2024, let the matter be listed before the same coordinate bench. Let the matter be listed after whenever the bail is bench is. Let the matter be listed whenever the aforesaid bench is available.
Justice, the above is sitting on the first.
This thing. So let this matter be listed after listed in the next week.
Item number 4.
Yes.
About where I'm praying for the release of an accused person in connection with the Dapolijah PS case number 16 of
What is the offense?
offense. Registered section is 109, attempt to murder.
Attempt to
And-
murder.
118.
Hmm.
Working hard.
Where is the FIR?
FIR is, my lord, page starting page 12.
15, page 15.
Page 15 is type copy, yes, my lord.
Yes, what is your submission?
On same date, he was arrested.
Hmm.
Earlier, here petitioner approached before the trial court for
Hmm.
bail.
It was rejected.
Rejected on the ground that the investigation is pending
Hmm.
and medical legal certificate has to be seen.
He's in jail since
Since date of the offense, 13 March 2025.
13 March,
2025. Now more than 5 months, madam.
more than 5 months.
Now, again, he moved after filing of charge sheet. Already charge sheet has been already filed.
Hmm.
He moved another bail application.
Hmm.
The Lanet court below is rejected again on the ground that considering the manner the alleged offense is committed and on the prehension that he might cause injury or harm to the victim if no reason bail.
Now what is after the charge sheet, what is the stage now?
Now, case it speaks for CC, consideration of charge.
Consider CC.
Now, difficult is, my lord, I am a sick person. Even before,
How old are you?
I am about 56, my lord.
Hmm.
56 years, my lord. Now, I have been having various ailments since 2023 before arrest. Now, at present also, I have been referred for treatment to the dreams here at Narlagan. Referral form is matter page 30. And from custody also, he has been produced to the, brought to the emergency ward several times. Page 30 is medical referral form.
This is only at the stage of CC only.
Yes, my lord. But he is a sick person and he is in the judicial custody for more than 5 months, my lord. At least I should be, my lord, provided with proper medical treatment, my lord.
That will be provided, no?
Yes.
That they will provide. That they will provide in the jail. All these facilities are there.
No, my lord. He is in it's a Dapolijah, my lord. There is no proper jail, my lord.
Hmm.
Basically, they make jail.
Well, this is for motion,
station.
it is motion stage, my lord, this matter. So record may be called for.
No, I
Yes,
am, my lord. I have an interim prayer.
Other, your lordship, otherwise, your lordship, in the recent judgment of this Darshan matter, your lordship, in state of Karnataka and X versus Rajasthan also, your lordship. So all this aspect has been considered even on the medical ground, your lordship. If it is immediately, your lordship, required and the state is not in the position to provide it, your lordship, then your lordship, that can be one of the ground to take into consideration, but only simply come with a ground that's sick or whether it is
Let
like
the CD come. Let the CD come.
PCR, my lord.
Oh, sorry, PCR.
Yes.
My lord, since accused is, my lord, in at the Dapolijah.
That one direction will be given that he will be given all
Yes, proper medical
Yes,
treatment.
medical treatment whenever he is that is required.
Yes,
my
your
lord.
Heard Mr. So and so appearing for the applicant. Also heard Mr. T. Lanet APP appearing for the state of Arunachal Pradesh. Respondent number 1. Respondent number 1. This application under section 483 of DNSS has been filed by the applicant. Filed on behalf of the applicant for granting, for releasing him on bail who is under the police custody for last 6 months since his arrest on 13th 2025 in connection with DRJPS case number 16/2025 under section 109 bracket 1/118/2 of BNS 2023. The learned next the learned counsel for the petitioner submits that the accused applicant is suffering from various ailments and he is not getting the proper treatment inside the jail in deposition. Therefore, he submits that this court may release him on bail so that he can get proper treatment outside the jail. Heard Mr. T. A.K. Learned APP of Learned APP. Learned APP. After considering the materials in the court, this court is of the view that at this stage, the scan copies of the PCR may be called from this is pending where district session judge
Basar,
Basar,
Lapareda.
Basar.
Additional district and session judge Basar.
call from the additional district and session judge court Basar. Let the PCR, let the registry call for the PCR, about scan copy of the PCR from the aforesaid court. In the meantime, it is directed that the jail authorities shall provide the required medical attention as and when the accused applicant requires. Release this matter after 4 weeks.
They pray in my lord on the 8th of September.
Let this matter be listed on 8th of September. Since the learned APP appears for the respondent, separate notice is not required. This sentence you agree.
Most of them.
Oblige, madam.
Item number 5.
Mr. Lordship.
Yes.
Yes. Your Lordship, this is a matter for the quashing the criminal proceeding in respect of the petition number 2, and this petition file after made the mutual settlement in between the parties, petition 1 and 2, which page number 37 to 38, annexure 3.
Yes, you have got whatever the supporting material you have. That day, this court has asked you to prepare the matter properly and come with some
That's true. That's true.
that you have come.
As much as possible. First of all, I just highlight some fact, Your Honor. First of all, my lord, in the FIR, the accusation is that the petition number 2 is used some fake documents and then after got the government
She
job.
got the appointment.
Yes, my lord.
She got selected and got appointment.
Yes.
Yes,
So after that, this FIR was registered
yes.
by the complainant side, the president of the AT, Arunachal Taekwondo Association. So after the investigation, the charge sheet is filed before the CGM, UPR. After that, the case is tried before the Honorable JMFC. After the endorsed the case to the CGM to JMFC. On 8/9/2025, the CC is tried before the Honorable JMFC court. And my lord, regarding this matter, the both parties settled the matter, complainant along with the alleged accused person, petition number 2. And then after this is a judgments. I marked the important portion, my lord. Paragraph 24, 25,
Paragraph?
24, 25. Almost same sections which alleged in the charge sheet against the petition number 2. So in this case, Your lordship, the
In this case also there was a settlement.
settlement, then after they go to the Honorable High Court, the Honorable not satisfy the case and dismiss the same, then both the party, the appellant go to the directly Supreme Court, then Supreme Court allow that matter and set aside the proceeding of the whatever going on
Okay,
before
let
the.
us go to, show me the paragraph 24.
Yes. Yes, my lord. May I read? Paragraph 24.
Yes, yes.
Yes. Some portion. It was urged that all the ingredients of the offences committed under section 468 and 471 and also section 420 IPC are made out in the charge sheet. Hence, even if the matter was compromised between the parties, the criminal proceeding could not be compounded under that basis. Since the offence involved also include non-compoundable offences. Subsequently, my lord, it was urged that even if no steps have been taken by the CBI since the charge sheet was filed in 1998, the same would not be ground for quashing the criminal proceeding once charge sheet had been filed. He submitted that in the view of the decision of this court, in Supreme Court bar SN versus Union of India, this court would possibly not to be justified in giving direction in the instant case, even under section Article 142 of Constitutions, since the Constitution bench had held that in exercise of its plenary powers under Article 142, this court could not ignore any substantive statutory provision dealing with the subject. It is residuary power, supplementary and the complementary to the power specifically conferred on the Supreme Court by statute exercised to the complete justice between the parties, where it is just and equitable to do so. It was further observed that the power under Article 142 of Constitutions was vested in the Supreme Court to prevent any obstruction to the stream justice. Likewise, 28 to 30, last conclusion part is 32. We therefore set aside the order passed by the High Court dismiss the petitioner's revision application number 42 for 2003, special case such and such, and quash the proceeding against the appellant. The appeal is allowed accordingly. So whatever the criminal proceeding of the same section was similar in nature in my criminal petition, my
It
lord.
was under 142
Yes,
power. This
142.
High Court doesn't have power of 140. You go on reading.
Yes, yes. The basic intention of the accused in this case appear to have been misrepresent the financial status of the company MS Nimach Embarrass Limited, Mumbai, in order to avail of the credit facility to an extent which the company was not entitled. In the other words, the main intention of the company and its officers was to cheat the bank and induce it to part with additional amount of credit to which the company was not otherwise entitled. Despite the ingredients and the factual content of an offense of cheating punishable under section 420 IPC, the same has been made compoundable under section 2 of the section 320 of CRPC with the leave of the court. Of course, forgery was not had been included as one of the compoundable offense, but it is in such cases that the principle initiated in the V.S. Joshi case becomes relevant. In the instant case, disputes between the company and the bank have been set as rest on the basis of the compromise arrived at by them, whereunder the dues of the bank have been clear and the bank does not.
Yes, I have read this.
Yes,
Yeah, your case is different from this case. And the Supreme Court has the power, 142 power.
that's true.
But this High Court doesn't have the power. And this is a serious offense that we have committed. It's not only simple. See, in that Supreme Court case, there was a commercial transaction. This commercial transaction was settled between the parties. Nothing was left. But here we have fraudulently procured some certificate, submitted those certificates. On the basis of those certificates, you got selected, and you have been appointed. What is the status now? You have resigned, or you have suspended, or whatever.
Suspended.
You have been working.
No. on that point of time, no voting to done.
Yeah, you were appointed, then what?
Yes. Then immediately case is
This
charged
case
with
came. Then you have been suspended or you have left job yourself?
suspended him.
So you're still on job, that means.
Might yes, sir, my lord.
Your case is a little bit different. And like making a compromise now with the person who has filed a complaint, you want to
Yes.
say that this case should be passed.
On merit motion.
Yes.
This may be disposed on merit motion. Lordship have
Then this will dispose of merit only. Compromise will not do in this case.
Yes, sir. This is a piecemeal settlement, whereas there is 19 accused, Lordship.
The charge sheet I have seen.
Yes.
I have seen the charge sheet. So I'll pass the order. I'll just rise for 5 minutes. Huh? I'll just come back. Yes.
Regarding the appointment regarding my lord, I just missed submission that they're not appointed, only the selected. Before appointing, this case is registered and the charge sheet is there, my lord.
So she was not appointed.
Not appointed. And my lord, if it this today matter is any pass any order, then it is possible to give me another chance so that I go another research if possible.
No. How can we have already given 2-3 chances. I think 2-3 chances we have already given.
Because last 3 days my father in hospitalized,
Oh,
so that
that-
I unable to proper preparation.
Yeah, you should be prepared on the past instance only. You have been given 2-3 chances. Heard Mr. So and so. Learned counsel for the petitioner. Also heard Mr. D. Loy, learned PP for the state of Arunachal Pradesh. Next paragraph. As agreed to by the parties, the matter has been taken up for disposal at the motion stage itself. Next paragraph. The facts of the case are that on 25/6/2021, an FIR was lodged by one Sri Kipa Taha, President of Arunachal Taekwondo Association in bracket ATA, bracket complete, for alleging that some persons have misused fake taekwondo certificates to avail jobs under meritorious sports quota under the government of India. Jobs were not under government of India.
It is advertised, but later on it is handed over to the state of Arunachal Pradesh.
Lordship, may I take you to the case number 34, Lordship? Yes, my brother is that she was not appointed.
34.
Yes, Lordship.
I think he was appointed.
Yes, Lordship. She was appointed, selected for the post of DGP history. Lordship.
But not appointed.
She was selected. Where is that advertisement? It is there in the petition.
No, my lord.
Not any.
What have you written? No, meritorious quota regarding government jobs. It was alleged that Government of India had notified 63 sports disciplines by reference number F dot no dot 14034 stroke 1 stroke 2013 dash ESTT, all capital, dated 1/9/2020. Comma, before the officer in charge, Special Investigation Team SIT, PHQ, Itanagar, Government of Arunachal Pradesh. After receipt of the FIR, the case has been registered and investigation was conducted. And thereafter, a charge sheet was filed under section 201/420/468/471 APC on 17/3/2022 before the Chief Judicial Magistrate UPR against 19 alleged accused persons, including the petitioner. As per the aforesaid charge sheet filed, the petitioner stroke accused applied for the post of PGT history under meritorious sports quota on the strength of several certificates as detailed in the charge sheet obtained from the General Secretary of Arunachal Pradesh Taekwondo Association for participating in the said events. Based on the qualifications so submitted by the petitioner was selected for the post of PGT history. However, after receipt of a letter from Sri Tadar Appa, Director Sports, Government of Arunachal Pradesh, and Sri Likha Ravin, General Secretary, Arunachal Taekwondo Association, it was found that the certificate of gold medal in 8th National Senior Pumse PWOMSAE Pumse Men and Women Taekwondo Championship bracket 2016-17 bracket complete, comma Visakhapatnam, comma Arunachal Pradesh, sorry, Andhra Pradesh, and certificate of silver medal in 9th National Senior Pumse Taekwondo Championship 2017 at comma Haridwar, Uttarakhand, comma of the accused person were not genuine. It was further alleged that in absence of any genuine certificate, the accused petitioner could not have obtained form number +2 certificate for the same event, which revealed that her form number +2 certificate was also fake. In fact, the accused petitioner confessed to have used fake documents along with fake form number 2 knowingly before the police. It was further alleged that she stated before the police that she obtained the fake certificate from accused Tara Tagim. In view of the opposite charge sheet, the investigating officer probably satisfied filed a charge sheet under section 420, stroke 468, stroke 471, stroke 34 IPC against the accused petitioner. Now the case is at which stage?
CC, consider the charges on 8th of September this year.
It is submitted by the learned counsel for the petitioner that accordingly the case has been registered before the judicial magistrate first class UPR district Papumpare Arunachal Pradesh, and the matter is awaiting for consideration of charges. Next paragraph. The learned counsel for the accused petitioner submits that the accused petitioner and the informant Sri Tipa Kaha
Pakaha.
who is Tipa Kaha?
The president of the ATA, Arunachal Taekwondo Association, president.
He is still the president.
Yes,
Tipa Kaha, the president of Arunachal Taekwondo Association in bracket ATA has come to an agreement and Accordingly, they have executed a deed of mutual settlement agreement dated third day, dated 3/8/2025. He submits that the parties have agreed to compromise and settle the proceeding of criminal case white case number criminal case that is CBPS case number 7/2021 corresponding to GR number 576/2021 pending before the opposite JMFC EPA. In view of the aforesaid mutual agreement, the learned counsel submits and prays before this court that this court, in exercise of its power under section 528 of BNSS 2023, was the proceedings of the CBPS case number 7/2021. Next paragraph. It is seen that this petition has been jointly filed by the aforesaid informant, that is, aforesaid informant, namely Pipa Kaha, and the accused petitioner. As far as the charges are concerned, which are the compoundable offenses, which are not? 420 is not compoundable.
Yep.
Correct?
468, 471.
468, 71 is not compoundable, but 420 is compoundable. It is seen that charges were framed against the accused petitioner under section 420, 468, 471/34 of the Indian Penal Code. And out of the aforesaid sections under which the accused petitioner has been charged, section 420 is a compoundable offense under BNSS. Oh,
IPC.
sorry, 420 corresponding to what? Because 420 was earlier, it was not compoundable. Now it is compoundable, I think.
In the IPC 420 is compoundable, Your Honor.
IPC 420 is compoundable.
Compoundable is
On
mentioned.
BNSS, it has become compoundable. Earlier it was not compoundable.
Mentioned in the BRIC.
Hmm?
In BNX.
BNX is compoundable, but both earlier,
In
imprisonment for 3 years and fine, 7 years and fine.
The-
420 is imprisonment for 7 years and fine, cognizable and non-bailable.
Lordship, 428, the relevant, in the CRPC, IPC, there was not non-compoundable in previously in the CRPC, Lordship.
That's what I'm saying. It was earlier not compoundable, but now it has been made compoundable.
Compounded.
Earlier it was compoundable by the person seated with the permission of.
Section 320 CRPC, go to section 320 CRPC. The 420 is not there. Under section 320 of CRPC, 420 is not included.
Part two in the area, Your Honor. In part two, it is available, my lordship.
Which part?
320 part two. Subsection part two. Subclause part, subclause two, my lord. In the column table is mentioned that 420 is compoundable
Part 2 offenses.
cheating dishonest, including the person cheated.
The person cheated,
Person cheated.
but here he is not the person cheated informant.
Okay.
If there is cheating between two persons, then it can be compounded. But this is not the person, he is not the person cheated informant here. But in BNSS now, corresponding to what 420 is corresponding to
318 also.
318. This charge sheet was filed earlier, right?
Earlier,
Because it will go by IPC only.
IPCS,
So there is no point we are looking into VNS. It is a non-compoundable offense.
March 2022, date of the charge sheet date.
What you written? No. Out of the FSS sections. Yes. Cheers. 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 Looking into. Charles looking into the offenses involved. None of the sections are compoundable as per the provisions of section 320 of CRPC. Full stop. The learned counsel appearing for the petitioner has cited the case of, in quotation, Nikhil Merchant versus Central Bureau of Investigation and another. Bracket, quotation complete, comma, reported in 2008, bracket 9, 2008, in bracket 9 SSC 677. He relied on paragraphs 28, 24 and 25. 24, 25, 28, 29, 30, 31, and 32 of the aforesaid case. A cumulative reading of the aforesaid paragraphs, it reveals is distinguishable from the instant case. In the aforesaid case cited by the learned counsel, the issue was between the company and the bank, and the company, by some misrepresentation, availed some additional loan. However, on filing of the complaint, the company readily paid back the additional amount and settled the dispute with the bank. And in that actual circumstances, the Honorable Apex Court has allowed the mutual settlement and lost the proceedings against the company. However, in the instant case, the facts are totally different, and the accused petitioner, with the help of certain fake certificates, got selected in a government job. I have considered the submissions made by the Climate Council as well as the TP. Peruse the materials brought on record. After considering all the materials in entire, the scope is of the opinion that the instant case does not merit any interference at this stage. Yes. Next paragraph. Accordingly, the instant criminal revision petition is dismissed and disposed of.
Much obliged.
Item number 6.
Item number 6, yes.
Well, here, this is an FIR relating, FIR filed by the CBI relating to a project called implementation of a horticultural project titled as establishment of orange cum pineapple garden at Kamrung Hotka of Page Hodge Village under Toru Circle of Apumpare district. Now, the alleged period of offense pertains to the year 2013 to 16, my lord. Now, my lord, may I request, my lord, kindly have a flash look on the list of dates which I have prepared just after the list of dates.
Yes.
Now, my lord, in July 2013, project
Project was initiated.
initiated
Yes.
by the accused number 7.
Now,
August to October 2023, my lord. Just thereafter, my lord, I'll take.
Who is the petitioner?
Is a DHO, District Horticulture Officer.
He is Pesi Yami.
Yes.
Okay, he is accused number?
Accused number 1. She has been made as accused number 1.
Accused number 1 in the charge sheet.
One is the charge sheet. That I'm coming to that.
Okay, so
The-
DPR was prepared.
Prepared
Uh,
and submitted by the accused number 2 and accused number 3.
Said, let us go to the FIR first.
Yes. Page 49 of the FIR.
Page 49.
Yes. Right. It starts from 43, my lord. Effective is.
Page 43, but like relevant
Effective
portion is at page, it start from
49.
page 49.
It starts from page 49. Information has been received from liable sources alleging that the accused so and so to so and so enter into criminal conspiracy with the accused NEC impaneled RLM, namely Dr. Kifili Angami.
Yes, okay, yes, I mean, where is the charge sheet?
Charge sheet is the lecture 2.
Next to page,
It starts from 57.
Page 57.
Well, the effective is this, the content rest are this all
Page
exhibits.
57, 53.
Page 53. 57,
No, you have given the relevant portion, no?
yes. Page, well, just, well, there is a,
So where is the portion wherein the accused has been charged?
okay. Accused has been charged, my lord, that kindly come to, no.
No, this is the FIR you have given.
Yes, Lord. Well, just,
Charge sheet, where is charge sheet?
well, just page, well, just something has gone wrong with my system.
And what is the stage now?
My lord, the framing of the charge,
It's the framing of the charge.
Hmm.
We'll issue notice now.
no, my lord, my lord, kindly come to last page, my lord,
Last page of what?
of the petition, my lord.
So your prayer. I
No,
have seen.
180. 180.
180.
Annexure 4, my lord. Now, my lord has seen,
Okay, Mr. Saikes, Justice Saikes.
yes. So,
Order.
my lord, what had happened is, my lord, just give me 1 minute so that I'll address my lord before passing.
What is your prayer here?
My prayer is to stay
Stay of the whole proceeding.
and in respect of the petitioner only, and also to pass and set aside the entire proceedings.
What is the interim prayer?
Interim prayer is for the stay of the proceeding. Because the court has already granted stay in respect of the 44 accused, in respect of the beneficiaries, my lord. ये थोड़ा हैंग हो गया, थोड़ा बाद में देखते हैं. It is okay. नहीं, I have. Page 39 onwards, my lord.
1 second. You are appearing for whom?
CBI.
CBI, I mean, without taking cognizance, charge sheet has been, without taking cognizance of the charge sheet, notices were issued over.
Correct. That part, I'll take instruction from the land court below.
Let him take instructions.
Whether
Let him take instructions, let the matter be fixed, let the matter be fixed after a week, let him take the instructions. And if he gets an instruction saying that notices were issued without taking cognizance of the charge sheet, then he may have a case like.
otherwise, my lord, prima facie, I have a case for indulgence of my lord because my
Okay,
system, there is some problem with.
No issues. I mean, see, I have, a coordinate bench has passed an order
Correct.
saying that on the basis of the submission made in that particular case, that that notice was issued without taking cognizance. So this has to be verified by him, and he has to come with his instructions. If you come with his instructions, and the same thing has happened as far as your thing is also concerned, notice has been issued to you also. Without, then you may have a case.
My lord, the predicament and prejudice in respect of the petitioner is that, my lord, C has only joined in 2015, Milord. The second installment. And all, C was not part of the preparation of the DPR, sanctioning of the project, and so on and so forth, Milord. C was just implementing the second installment of the fund. Now, how a person, then secondly, Milord, secondly, the person against whom, Dr. Dr. Angami, Milord, the person against whom the FIR was initially registered in Meghalaya, Milord, has been delisted from the prosecutions, Milord. These cannot be permitted, Milord, because prima facie, if my lord reads the charge sheet also,
Okay, we'll issue notice at this stage, Mr. Tara. So like, let him come with the instructions, he may have a good case.
Yes.
And the
Okay.
next day, the court will say, heard Mr. T.T. Tara, learned counsel for the petitioner. Also heard Mr. M. Kato,
Yes. Lord.
learned standing counsel for CBI, for both the respondents,
What the response?
for both the respondents. Issue notice returnable in 4 weeks. Issue notice returnable in 2 weeks,
Madam,
because you just need to get the instruction.
I'll come with it.
Returnable within 2 weeks. As Mr. Kato, learned standing counsel for CBI, has entered appearance for respondent number 1 and 2 and accepted notice. And no formal notices are required to be sent. However, if soft copy, however, requisite extra copy of the petition along with the documents appended there to be furnished to him by today,
furnished today.
during the course of the
No, I am furnishing.
during the course of the day. Heard the learned counsel for the both sides for interim protection. This court, after going through the materials on record, is of the opinion that the instruction as to whether the learned trial court below issued notice to the accused person without taking cognizance of the matter or not. I just forgot what did I write? This court is of the opinion that the instruction may be required. Yes, instruction may be required. So and so. The learned standing counsel for CBI is directed to submit his instructions in the next date of instance. On his submission of the instructions, the interim prayer in the instant petition will be considered.
Madam.
Place it after prayers.
Development.
Item number 7.
Has been filed before this honorable court, your lordships, for alteration or modification of the condition of bail imposed by the learned court below, your lordships, on 19/8/2025. Only one condition, that is the requirement and imposition of local surety. The petitioner before your lordship is permanent resident of Bihar, Samastipur. She was arrested in way back on 22/4/2025 in 0 PS case number 8/25. She got finally released on bail on 29/5/2025. Thereafter, on the same very day, another FIR has been lodged, which has been registered under 0 PS case number 34/2025. Thereafter, bail application has been moved before the honorable court and has been already been directed to release the petitioner.
In the other case also.
In the other case
In the
also,
other FIR also.
yes, in the other FIR also.
First FIR filed,
The
she was
honorable court,
granted bail. She was granted bail.
this honorable court has granted bail. Second FIR,
filed,
this court has been directed to submit a application since he is entitled for default bail, and the direction has been given to the learned court below to release the petitioner.
but the thing is that is on 14/8/2025, when she submitted the bail bond for the execution is her of her bail bond, she produced two sureties from Namsai district of this Arunachal Pradesh. The learned court below has refused to accept the sureties as directed by this honorable court in
Where is it direction?
Lordship. First bill, this honorable court has been directed.
This honorable court has directed, not
Yes,
has
yes.
been directed.
Lordship. On 29/5/2025, Annexure H.
Annexure H.
Yes, with the relevant portion is page 30.
We'll take up this matter after,
Lordship.
because we have some, we'll have to visit the bar actually at 1 o'clock.
Lordship.
So we'll take up the matter after.
Lordship. Alteration or modification of the order dated 19/8/2018, which is
Where is their order?
Lordships. The order is page 32. And the relevant portion is page
You have come under 528
Lordships.
against,
Against that condition has been imposed by the learned court below. The first condition, which is page 34,
so you have been allowed to go on bail.
bail.
But the condition,
Yes,
the condition, first condition, yes.
the accused Rina Kumari alias Rina will be released upon furnishing a bail bond of rupees 15,000 with two reliable and solvent securities of like one. One of the security has to be a local person, and both the securities shall be furnished present and permanent address proof along with the contact numbers. Yeah,
So you have a problem with the local person.
local permanent person. Though I have submitted the bail bond with two persons, which is page 39. Kindly, Your Lordships. I've given one Tailang Wangsu, who is working under the SP office 0, and another one is Susan Chow. He's hailing from Namsai district. And I have also annexed the permanent residence certificate also.
So what happened? Why it was not accepted?
The learned court below insisting upon the permanent resident of the locality of 0, the surety, defying the honorable apex court judgment on number of pronouncement, whereby the courtman may alter or modify the bail conditions, and not upon insisting upon the local surety also. May I also place this among the judgment also?
As far as the court below might have the problem with the problem that one of the persons is not the resident of local jurisdiction of 0. That's what the problem is,
Yes,
right?
yes, that is a problem. But
So who stays in 0? Who doesn't stay in 0?
Tunglai Wangcho, the page 39, the person who is right now working under the superintendent of police office is temporarily resident of 0.
He's not a permanent resident of 0.
Lordship. He's not a permanent
resident of 0.
But on the other hand,
this person is from Namsai.
Namsai.
So
relying upon the honorable.
No, where so you went there and with these bail bonds and your bail bonds were not accepted.
That is the one of the factor that the court below has verbally instructed or informed us to produce the surety from the local person, not in a written format. They denying the bail, accepting the bail bond, directing us to submit the local resident of the 0 of the surety. He has not been till date. He has not been any kind of order, but without accepting that this bail bond, he verbally instructed us. But the thing is that the Honorable Apex Court and numbers of direction has been issued not to impose any kind of local surety. Though the person, it is a tremendous task for her to arrange a lodge. First of, I will rely upon the Motiram judgment and your lordships.
But there are plenty of cases. If you show me one page.
Lordships.
So you don't have any issue with the other, that learned.
There is another aspect, your lordships, the court below has not been,
You have any more issues or like only this
no,
image?
yes, no, only much. The court below has to accept,
Which paragraph you are relying in, paragraph 33
lordship,
in Motiram case?
Motiram case pair 33. Pair 33, your lordships. And another is Sumoto court has taken direction by the Honorable High Court, where in direction number 6 and 7, the court has specifically mentioned, your lordships, the
6 and 7, which 6 and 7?
lordship in another judgment, your lordships,
Which one?
in 2023, your lordship, I placed this
Judgment, you tell the name or the citation.
lordship, lordships, policy strategy of for grant of bail in 2023 SEC online 483, whereby the direction has been given by the Honorable Supreme Court. Apex Court,
Which para?
lordships. In this case, there is no separate, but there is a direction number
You
one.
tell me the paragraph.
Possible নহয়.
No, which case you are referring to?
In is this, sorry.
2023 SSC online Supreme
Lots.
Court 483.
Lordships.
It is there with me.
Lordship there.
The two copies are there.
Yeah, 2 copies are there. That is why my copy is placed for Lord. Case number,
Which paragraph you are referring?
yes. In pay, there is no mention. Paragraph number,
You should come prepared.
lordship.
You should come prepared
Lordship.
for the case. You have
Lordship,
got
page,
enough time.
lordship, page number,
We are arguing the case before I.
lordship, page number of your days, point number 6. This is a last, next to last, page number, point number 6. If the bail bonds are not furnished within 1 month,
Which case? Point number 6, which paragraph?
lordship, paragraph number 9. Paragraph number 9, down below, directions. if the bail bonds are not furnished within 1 month from the date of grant of bail, the court concerned may suo motu take up the case and consider whether the condition of bail require modification or oblique relaxations. Number 7, one of the reasons which delays the release of the accused convict is the instance upon the local surety. It is suggested that in such cases the court may not impose the condition of local surety.
Take down, take down. Heard Mr.
H. Burua.
H. Boro, learned counsel, appearing for the petitioner. Also heard Mr. D. Loi, learned PP for the state of Arunachal. For. Who is this Nakot Tatani?
Is a informant in this case. We made a party since
Why
he
do
is
you need to make him the party?
a
Then I'll have to issue notice.
Instead of filing before the court,
No, it was not, no, it was not accepted by the court. What he will do, he is not passing any order. He is not passing any order. He is not accepting the bail bond also. He is simply saying orally that you come up with local security, and he is not really releasing the person in spite of passing of the order. This is not correct, no? He is not. Who has passed the order? The High Court only.
Lordships. This in 19th order is Lanet Court below. These Chief Judicial Magistrate 0 Lordships, Lower Suburbanchari districts. Page number
And who is not accepting the CJM only?
CJM only.
You have anything to say? Why is not accepting? But you have made this person a party.
Lordships.
he have to file for alteration and modification.
Where?
Before the court who passes the court.
No, there is a provision is there.
It's why the local security was insisted. He is insisting.
In that case, he may.
Now, why local security is given? This word local should not be there.
Yes, that's why he should. Any government employee may be lordship.
Yeah, he's a complaint.
Any government regular government employee lordship.
No. We'll.
The person is a local employee of the superintendent of police. He's a constable, police officers. Who is hailing from 0, who's working under the superintendent of police. He's 0.
But he's on permanent submission only.
No, yes. I have.
No, he has submitted this document, Mr. Lohi.
Type copy is
He
there.
has submitted these documents on oath.
Annexure 40,
with the
Annexure L, page
application.
44.
He has given these two names. See, it's there in page 39 and page 41.
And page 44 is a identity card.
All these things he have given. See, I will modify this order. And ask and
Government a regular government employee lordship.
no, I mean, see, what was the condition? Condition was nothing. Government employee, something, it was not there, na, initially.
Earlier bail order to local security lordship.
Ah,
So
and
it is not possible to give
two local security, he has given security only, he's giving from owners. Local means all over India.
India.
It's not only in 0, only in this thing. That has been stated in many Supreme Court cases.
Lodge.
Correct. So local doesn't mean it's, if it is allo. He's giving two securities from, one from Namsai and one is from 0. One is a government servant. In spite of that, he's his bail bonds have not been accepted. So I will pass an order modifying this order. I'll pass an order stating that this security should be accepted. Okay. And another thing is that I am disposing of this petition at the motion stage itself because this person is not required.
Lodge.
This case.
Lodge.
You write down their names, I'll dictate the order in the channel.
Lodge.
Item number 8.
Wait, please, your lordship. Lordship, this is a joint petition filed under section 528 of the BNSS. Joint petition, your lordship, for quashing of criminal proceeding
Why?
in GR case number 647 of 18 in terms of settlement between the parties, your lordship. The petitioner number,
Parties means who?
the husband and wife. The petitioner number 1 is the alleged accused husband, and the petitioner number 2 is the wife, your lordship, the complainant. So,
Where is the complaint?
your lordship will file the FIR, your lordship,
FIR where?
at page 21 as annexure number 1.
Page 24.
21, your lordship.
21.
Yes, and
Relevant person.
relevant person is 22 also is there.
The contents of the FIR you will find in page 24.
Yes, your lordship.
Come to that.
May I read out, your lordship?
Yes.
The complainant begs to submit that the opposite party number 1 is the husband of the complainant, and opposite party number 2 and number 3 are the father-in-law and the mother-in-law of the complainant respectively. The complainant and the opposite party number 1 fall in love for 5 years, and as a result, on 4/1/2018, they tied their bond as husband and wife by executing a memorandum of agreement for marriage before the Notary Public Lakhimpur, North Lakhimpur, in front of witnesses. On the same day, the opposite party number 1 put vermilation to the complainant at Ganesh Mandir, North Lakhimpur, before the priest. After 5 days of marriage, the opposite party number 1 and the complainant went to Guwahati and stayed at Prince Hotel, Paltan Bazar, for 4 nights. After 4 days, the opposite party number 1, under bracket my husband, sent me to Naharlagan in a day super, and he went to Pune to join his job. Next page, page 25, your lords.
Yes.
From Pune, my husband called me several times in a day and tortured me mentally by using many slang words and started to demand dowry of 10 lakhs. I decided to go to Pune to meet my husband accordingly. On 18/2/2018, with my father, mother, and my brother, Mantos Saha, we started our journey and reached on 23/2/2018 at Pune. After 3 days, leaving me there, my parents and my brother returned from Pune. After that, every day my husband started to torture me, both physically and mentally, and neglected me as I am a Bengali girl. He demanded dowry of rupees 10 lakhs again and again. I denied to pay the same. My husband threatened me to destroy me by killing himself if I do not pay this demanded dowry. On 17/7/2018 at 3 p.m., making a drama, he hanged himself with my scarf at Pune at our rented house. Somehow, I saved himself and admitted at hospital, Pune. After 2 days, my husband's elder brother, Sri Santosh Mahato, with his wife, reached at our rented house, Pune, and brought us to Banaras, and thereafter sent us to Naharlagan, Arunachal Pradesh. On 27/7/2018, we reached at Naharlagan and discussed our serious matter in front of both family members. My husband and my husband's family members, opposite party number 2 and 3, misbehaved all my family members at my residence. On 31st July 2018, I went to my husband's house, and all the members of the opposite parties all night tortured me physically and mentally. I sustained injury on my neck, and ultimately on August 1/2018, the opposite parties dropped out me from their house. My husband told me that he will divorce me. In all these incidents, the opposite party number 2 and 3 were fully involved, and as per their advice, my husband tortured me physically and mentally. This is the content of the FIR. Initially, this FIR was lodged before the Nirjuli police station. And after that, your lordship, this FIR is of 4 August 2018. And later, this complaint was transferred to Women PS Itanagar on 11/9/2018. And then only this FIR was registered. So the FIR, which I have annexed as annexure number 1, in page 22, There is also one content of FIR, your lordship.
Then it has gone to Omen police station and page 33.
Yes, your lordship. The case got registered at Itanagar Women Police Station. Thereafter, the charge sheet was filed and
Very charge.
the charge sheet. Page 26 from 26 to 76, your lordship.
26 to 27.
26 to 76.
26 to
76. Connection number.
26 to 76.
Yes, your lordship. Starting from page 26.
You don't need to give me all the details. You just give me where the charges have been leveled against her. Charge sheet will contain statements and all
Yes,
these
your
things,
lordship.
FIR and all this. You just tell me where the charges have been leveled against you. Is it at page 33? Yes. Huh? 33.
Page 33, your lordship. The prosecution story at page 33, your lordship.
So you have been framed under which sections?
Section 498A and 506 of the IPC.
506.
Yes, your lordship. 506 compoundable, your lordship. Criminal intimidation, punishment for criminal intimidation.
Now in the charge sheet, you have been charged under 498.
498A. Initially, the case was registered under section 498A and 323 of the IPC.
Then what happened in the trial court?
During the trial, by court order dated 16/1/2020, that your lordship will find at page
Case
77.
is today fixed for CC.
Yes, your lordship. By court order dated 16/1/2020, the charge was framed under section 498A and 506 of the IPC.
506, who has put in 506?
After hearing all the counsels, your lordship.
So
The
CC
court,
has happened. According
yes,
to
your
the-
lordship.
The today's case is placed for 16 year hard to provision of that with respect to consideration of charge under so and so. Okay. Now what is
So
the state?
now, the stage is at defense witnesses. The next date is fixed for defense witnesses, your lordship.
Yes, now
the
where is the agreement of settlement?
At page 79, your lordship,
When it was executed?
on 25th of August 2025.
What is the what are the contents?
Your lordship, at page 80, may I take your lordship to page 80? That is the second page of the settlement deed. At paragraph 4, may I read out, your lordship?
Wait. (498) is not compoundable offense.
Yes, your lordship.
506 is
It's compoundable, your lordship.
compoundable offense.
Only section 498A.
Yes, Mr. Lohi, what do you have to say? It's a marital dispute.
Yes, they already settled their dispute.
Hmm.
They buried the head.
So in this kind of cases, Supreme Court has, in many cases has,
In line with the Lakshmi Narayan case.
yes, Lakshmi Narayan cases there.
Your lordship, I have mentioned that in my para 16, of my petition, your lordship.
What?
Yes.
Lakshmi Narayan case?
Yes, your lordship. Since your lordship, the Honorable Supreme Court has settled in this such cases, your lordship, that criminal cases which have civil flavor, your lordship, and
more categorically those which are of marital discord, marital disputes. This honorable court can quash, Your Lordship, by exercising the power under section 528 of the PNSS.
I think, yes, I'll dispose of the case. You write, their names. Take it.
Deeply obliged. Item number 9.
Your Lordship, in item number 9, though we have sent the notice, Your Lordship, however, we are not able to find because the address given is not in a proper manner, Your Lordship.
So service report is not,
Yes, Your Lordship.
respect of who is not received.
Yes, Your Lordship.
The POXO matter.
POXO matter, Your Lordship.
My lord, in this regard, allow me to take precise step, my lord. And there is two,
Mr. C, so and so appears on behalf of the petitioner, and Mr. MST Gini, learned APP appears for the state of Arunachal Pradesh. Seen the office report dated 28/8/2025. It reveals that service report in respect of respondent number 2 is still awaited. Full stop. Next para, the learned counsel for the petitioner is directed to take fresh steps for service of notice upon respondent number 2 within 2 days. Within 3 days. Within 3 days. The such service will be carried out through the office of PP. The same will be executed by the concerned person. This is after 2 weeks.
my lord, fixed date may be given, my lord, on 11th.
Don't write 2 weeks, right? Fix this matter. Let this matter be fixed on 11.
Deeply obliged.